Good afternoon, Mr. Millar.
Good afternoon, Chief Justice, members of the Commission.
Are you well, sir?
I'm very well, thank you, Chief Justice, and yourself?
I'm very well, thank you. You've been an attorney for about 27 years, am I mistaken?
26 years this year, Chief Justice.
26 years.
I'm flowing into the 27th.
Oh, yes, oh, yes. And I take it was, or it is a busy practice.
Yes, we keep ourselves busy, and there's always things to be done. An attorney's job is never done. There's always things to keep you occupied and keep you moving forward.
And I take it you are here because you believe that experience, together with your acting stint as a judge, have prepared you for the position of High Court judge.
Yes, Chief Justice. I believe that the cumulative experience I've gained in my practice as an attorney, and also the opportunity that I've been given to act, has prepared me where I believe that I would be able to acquit myself and discharge my duty as a High Court judge if appointed.
Thank you. Colleagues, may I have the names of those who have questions for Mr. Millar?
Nyambi.
Jenny Kane.
Dodovu.
Schlemmer.
Mpofu.
Leo.
Arnold.
Sigogo. Madonzel.
Tepeche.
JP, over to you.
Thank you very much, Chief Justice. Mr. Millar, good afternoon.
Good afternoon, JP.
Yeah, the Chief Justice covered part of my questioning, but your acting judge work allocation spreadsheet tells me you've acted for a total of 76 weeks.
Yes, sir.
And it spans a period from 2017 to date.
That's correct.
But what other candidates don't match with you is that you've had a solid 8 weeks in the urgent court.
Yes, Chief Justice.
No, sorry. I don't want to get into
sorry,
trouble.
JP.
Thank you. And you've also had a solid 8 weeks in the opposed motion court.
Yes, JP.
You've also spent a full term doing criminal trials.
Yes.
Right. Have you had any problems with any of your allocated work areas sitting in the urgent court, opposed motions or special motions?
JP, not at all. I've found that I've been able to cope with the work that's been allocated to me, and the work's been done timelessly.
Yeah. And in terms of your judgments that you've handed down, you've got a spreadsheet that the commissioners have, and your trend is not to reserve for longer than 3 months. In fact, it's very quick. Within a month or two, all your judgments are out.
Yes, JP.
Have you had a judgments that you had to deliver beyond 3 months?
No, JP, nothing beyond 3 months. There was one matter where it was a full court appeal, which I think was delayed slightly because there were other parties involved, but not that I've penned personally and solely.
Yes. Well, we know the hazards of sitting in a full court appeal. It's not only you're sitting with others, isn't it?
Yeah, correct.
Yeah. Thank you very much, Chief Justice. Sorry, but the way you've behaved, written your judgments, handed them down, and the time you've given acting, you feel it's prepared you very well for a permanent appointment.
Yes, Judge President, I believe that I'm as prepared as I can be, and that if appointed, I would acquit myself, and that the Commission's confidence in me would be justified.
Yeah, this is the second time you come before this Commission.
Yes, Judge President.
Thank you. Thank you very much, Chief Justice.
Thank you, Honorable JP. Honorable MEC.
The MEC has stepped out, CJ.
All right. Honorable Nyambi.
Thank you, CJ.
afternoon, Mr. Miller.
Good afternoon, Mr. Nyam.
You are known to have championed lower legal cost of your clients. What are the demographics of your clients and how have your actions contributed to access to justice?
Mr. Nyambi, the vast majority of the clients that are represented in respect of the legal cost issue were clients from disadvantaged backgrounds. Persons who placed their hands or their lives in the hands of legal practitioners who were going to obtain redress from them, whether road accident fund cases or cases against the NEC in respect of birth injury claims. Across the board, all of them without exception were very big claims. And unfortunately, there are those instances where practitioners don't do things according to the law, and it results often in serious overcharging. We've recovered in many cases, for those clients, millions of rands. In individual cases, the amounts in some cases were in excess of 2.5 million rand recovery in respect of the legal fees component only. So it's important for access because the public need to have confidence in the legal process. They need to understand that when you go to a lawyer, it is someone you can trust, somebody that is going to look out for your interest. Yes, the lawyer must be paid for the work he does. It's important. We're all trying to make a living and they must be fairly compensated. But there's certainly no right because your client is in a particularly vulnerable position or doesn't have the knowledge or experience that you as the lawyer have for you to then exploit that person. It's a form of exploitation and it can't be permitted. So I believe that in the work that I did, besides helping my individual clients, it helped to send a message to the wider legal profession, but also to clients that if you're unhappy and there is an issue you have with the legal practitioner, there are other legal practitioners who will come to your assistance. It's not a closed shop or a situation where once something has happened to you, you're now left with no recourse. So I believe in the publicity that attached to those cases, because many of them did have publicity, set the word out amongst the general population, particularly those who were in that situation, and then empowered them to come forward, whether to myself or to many other legal practitioners who were prepared to do those cases and to then assert their rights. And if you look at the judgments that have been handed down, you can see across the provinces there's an increase in those types of judgments. So I think I'm quite proud of the role I played in being able to put that aspect of the legal profession on show to the public so that they would be aware that, in fact, we're not a closed shop. We're actually here to serve the public.
No, I commend you for that good work. Besides the issue of the cost, what else poses the biggest challenge when it comes to the issue of access to justice?
Well, I think the biggest issue is knowledge of rights. Many of the people in our communities don't know what their rights are. And that's the cause of that may be a combination of things. Laws that are complex and that aren't easily understandable by people, but also the availability of legal practitioners. I believe that we really need a profession that extends and expands across the entire country, so that wherever someone finds themselves, they're able to access a lawyer and then be able to explain the situation and then assert their rights. So it's an issue for the future, and it's an ongoing and developmental issue. We have a resource challenge within our country, both physical resources, but also knowledge resources. We're building and we're developing. And as we build and we develop, that will then roll out and there'll be a wider awareness of rights and a wider take-up of the implementation of those rights.
Thank you, Mr. Miller. Thank you, CJ.
Thank you, Mr. Nyambi.
Thank you, Honorable Nyambi. Commissioner Matolo Zepu.
Thank you, CJ, and good afternoon, Mr. Miller.
Good afternoon, Commissioner Leku, or should I say Chair.
I have to declare that I've known Mr. Miller for quite some time. him being a member of the BLA, and also he's a present council member of the Legal Practice Council, which I'm chairing. So don't forget, I'm not chair here. Okay. So what I want to I know we have been together for some time fighting for transformation of the profession, and now I'm quite worried that we are about to jump ship when we haven't gotten to actually to finish, you know, the race. But with your in-depth knowledge of transformation of the profession, can you just maybe briefly just tell the commission what are the 3 challenges that we are facing in trying to transform this profession?
Thank you, Commissioner Leku. I think the challenge with the transformation of the profession is really integrate. The first challenge I would say is integrating the 2 arms of the profession, the bar and the attorney's profession. Previously, they were regulated separately, one under the Admission of Advocates Act, the other under the Attorneys Act. The Legal Practice Act brings us together to a single regulator. And that's on paper and now in practice a single regulator, but we still have 2 separate fields of endeavor within this unitary legal profession that we share. And it's bringing 2 different bodies, 2 different fields of endeavor, really working towards the same goal and the same outcome into a single regulator with a single regulatory culture, but also to create an environment where the particular needs and demands of the individual components can be met within that context. And I think that is where the first challenge comes. You know, the attorney's profession was taken by statute. There was no choice. I think if there had been, we wouldn't be sitting with the Legal Practice Council. We'd be negotiating for another 100 years probably. It was taken by force, and I think that was correct. The advocate's profession wasn't taken by force, and I think one must understand that the advocate's profession has been through successively oppressive regimes. It's an old institution. It's got to find itself and bring itself within the framework of the LPC. It's taking a little longer than one would have liked, but I think there's very good progress being made in that direction, and I'm hopeful that eventually we're going to have a situation where we have a single regulator, but sensitive to and accommodative of the needs of the individual fields of endeavor. We need advocates. We need professional advocates. We need attorneys. They do different work, and they're really 2 halves of the same, or 2 sides of the same coin. They need to coexist and to work together, not work separately, you know, and pull in different directions. If they pull in the same direction, I think what we will achieve and what we'll see will be far greater. So that's the first challenge that I see. The second challenge is allied to the first challenge, which is really when information and the coordination will take place. We see, for example, that the LPC has taken great steps and great strides towards expanding access to pupillage and to empowering prospective pupils through the stipends that have been arranged with CESITA, so that those who come from backgrounds where they wouldn't have afforded it beforehand will be able to do pupillage. So we see moves in those directions, but that's the bigger picture of what is being done. But it's still happening within the framework of the established bar councils, all 14 of them for the individual divisions of the High Court. But then there are also bar councils that are outside what's considered to be the established bar councils, and about 25% of the total number of candidates or practitioners who are registered as advocates don't fall within what's considered to be the traditional bar. So it's a case of it's trying to bring them together as their profession, so that they can also then be regulated and be coordinated in order to move more, to move forward. The third challenge is I think an economic one that we face, and it relates to things like briefing patterns and access to work. And at the moment, we are in the process of addressing that as the Legal Practice Council. Yourself and other members of the council and many of the esteemed council present here are aware of the steps that are being taken to regularize the profession within the economic framework that synchronizes with government, so that the profession as a whole, but the individual components can then work with each other and with government in order to move forward to transform. And I'm referring specifically to the development of a legal sector code, which is going to provide a specific framework within which that can be done. Until now, it's been voluntary. And we've seen after 25 years that voluntary steps only go so far. Very often, you need to be pushed. And I think that's true of us as people, but perhaps professions also, that sometimes the fear of the unknown is really what is holding things back. Not necessarily that what will eventuate is going to be a problem. It's just the uncertainty. So I think we're on the cusp of addressing particularly that concern, and I believe that those issues will play themselves out, and the parties involved are parties of goodwill. They give their honest opinions. It's debated honestly and openly and robustly, and on that basis, I believe that the challenges that are there are going to be overcome.
Okay, thank you, Mr. Millar, and thank you, CJ.
Thank you.
Thank you, Commissioner. Advocate KNSC.
Thank you, Chief Justice. Good afternoon, Mr. Millar.
Good
I need you to please assist me in relation to this concern. On a review of your judgments, there's a distinction drawn between the area of expertise, the road accident fund work, and other types of judgments. And the distinction is, as I understand it, that in your RAF matters, your judgments do demonstrate sound reasoning. And in the other areas of law, there's a qualitative difference, and that sometimes it's being picked up that you leap to conclusions without a rational process that the reader of your judgments is capable of following and understanding. Could you address that concern, please?
Yes, thank you, Commissioner Kane. I think let me start first with the issue of the road accident fund cases. Yes, I have extensive experience in that area of work. It's quite a massive area of work that dominates all the courts in the Republic. I read an article a few days ago in which the Chief Executive Officer of the Road Accident Fund, Mr. Collins Letswalo, remarked that there are presently 189,000 road accident fund cases before the court. Now, yes, that is an important area of work. There are presumably 189,000 South Africans who are looking to receive compensation. One can accept that all of them have either suffered injuries or have lost loved ones, because that is the basis on which one approaches the road accident fund for compensation. So yes, that is an important area of work. It's absolutely essential that our courts address it, and with the particular challenges that go with it. So I appreciate your compliment in regard to the judgments that have been written in regard to those matters. I regard them as very important and affecting the lives of individuals very profoundly and very directly. In regard to the judgments, the other judgments, the criticism leveled by the General Counsel of the Bar focused on two matters. The SM versus AB matter, which was a matter involving a mother and daughter who sought an interdict to prevent the distribution of very private communications between each other and communications they had with third parties. They sought to interdict that. That information had been obtained by the ex-husband and was being used to maneuver and it was being used against their interest. I've set out the reasons, specifically what happened in the matter in the judgment. So there's that matter where one criticism was raised. In that matter, I referred specifically to the rights to dignity and the rights to privacy and the best interests of not only the lady concerned, but her child. And the second matter is the Lekwa matter. You'll forgive me if I just deal with both, but there's a common thread for both, which I will deal with afterwards. Was the Lekwa matter, which were special allocations. It was 2 urgent applications, and this is really the point. The SM matter was also an urgent application. Two urgent applications that were brought by communities to interdict the limitation of electricity supply by Eskom. The cases as made out demonstrated profound and very serious consequences as a result of the limiting of the electricity supply, the switching off of the water reticulation, that's the sewerage, hospitals being affected, emergency services, and so on. Both of those matters dealt with or were dealt with as urgent applications. They weren't dealt with as armchair cases, if I can put it that way, and no disrespect to any other type of case. But I didn't have the luxury of a week or 2 weeks or 3 weeks to sit back and research and decide and pen and craft a judgment for posterity. There was a very...
Yes, thank you. In fact, you fully satisfied me, so I'm going to stop you. I do really understand the distinction that you've drawn between armchair positions and urgent court. If I could just ask you one more question, please, on a different topic.
Yes, Ms. Kane.
You've expressed views in relation to the unification of the profession, and I know you hold strong views in that regard. Could you explain to me how attorneys' firms that don't necessarily have in-house experience in an area of law would get the benefit of a separate referral profession where the cab rank rule applies and they're able to avail themselves of a leading practitioner at the bar to deal with a particular case and still retain that client, even though they may be a small firm, a rural firm? How do you dispense with that advantage that is currently available to such attorneys? If you could just
Yes, Ms. Kane, I think...
give me a short answer on that question, please.
Yes, I think perhaps we're at crossroads because I'm not advocating the abolition of the bar as a part of the profession. You'll recall earlier I've said that the bar as an institution or as a field of endeavor is essential to the functioning of the legal system. The attorneys get the work and will be the interface with the client, and the advocates with their particular areas of proficiency and speciality are then available on the basis of a cab rank rule to be briefed and to render the services to those clients. So it's absolutely essential that we maintain both parts of, or both fields of endeavor. The challenge isn't, and the issue isn't to abolish the practice of advocacy as a distinct part of the legal profession. The challenge is to bring it within the ambit of a single unit, a single regulatory profession, and a single vision of the profession as to what is going to be achieved. So I'm certainly not advocating, and I've never advocated for the abolition of advocacy. I think it would be self-destructive to the practices of attorneys, and it would certainly not be in the interests of the public at large, who rely on our eminent and very senior and competent counsel to get up and argue for their rights. So
Thank you very much. No, you have answered my question. I'm cutting you short solely because of our time pressures and not because I'm finding your answers of immense interest. Thank you. Thank you, CJ.
Thank you, Ms. Kay.
Thank you. Thank you,
Follow-up,
Sim.
CJ.
Is that Commissioner Sigogo?
Yes, CJ.
Please go ahead, sir.
Good afternoon, Mr. Miller.
Good afternoon,
How are you?
Mr. Sigogo. I'm well. How are you?
I'm good, thank you. You indicated that you had the CEO of the RAF that their matters in court are about 189,000 countrywide. Will you agree with me that if a specific field of law can occupy our courts with such number of cases, we also need judges who specialize in that field in order to deal with such cases?
Yes, Mr. Sigogo, I agree, and I think it's essential. Road accident fund cases are not simple cases. There tends to be an impression that it's simply a matter of filling in forms and sending forms in. But the cases are often very complicated and complex. They involve matters relating to engineering, relating to motor vehicles, and the specific mechanism of what has happened to cause the collision. And once liability is established, then one has to deal also now with medical aspects. It's not that the attorneys or the advocates that are dealing with those matters are themselves medical practitioners, but they need to have a sufficient understanding to know the direction for the preparation of the cases and how things need to be done. With that, with knowledge of those things, very often one is able to get to the issue a little quicker and to facilitate either a resolution of whatever the issues may have been between the parties, or to then deliver a judgment that deals pertinently with what was in issue without taking court time to hear extraneous and unnecessary evidence, because you have the knowledge and experience to see exactly where the issue is. So I think it is important to have practitioners and judges with that experience.
CJ, with your permission, if I may ask my question so that I may forego my space later on.
Please go ahead, sir.
Thank you. Will you tell this commission, as a white man, why did you see value in participating in the transformation of the legal profession, particularly playing role in the Black Lawyers Association, the Law Society of Northern Provinces, Legal Practitioners Fidelity Fund, as well as the Legal Practice Council?
Thank you, Commissioner Sigogo. At a very early stage in my career, I've always held the views that I have now. My views haven't changed. And it became apparent to me quite early on that the home for my views, because those were my views, was the Black Lawyers Association. And so I joined the Black Lawyers Association because I subscribe to the values and the principles in the Constitution, and that is who I am. And that is the path that I chose. The organized attorneys profession at the time hadn't yet caught up. It was just post 1995. It was still catching up. It was taking steps. It was moving, but it wasn't moving at the pace that I thought it ought to have moved. I was still a very junior practitioner in those days. So my home was the Black Lawyers Association. As time passed and I gained experience, and I suppose it happens with all practitioners, that with time and experience, one's confidence grows and one becomes a little more outspoken with one's views. I then started to move forward, and the Commission will recall the last time I appeared here, I did give an indication of what had happened with regards to the then Law Society of the Northern Provinces, that for 20 years they'd had no election, there were bottlenecks, things were not happening, and the component, because of the structure at the time, that wasn't having an election was what one would call the white component, the non-BLA, non-NADEL component, which on the face of it really had nothing to do with me because I was part of BLA. BLA held regular elections. I voted for my candidates when we had elections and took part in the process. And so my voice was heard through the BLA on that council. But when the opportunity arose, the then president said to me, after having called for the election, I initially called for the election and I wasn't going to put myself forward, but the then president, after the members voted for an election, Mr. Mabunda, said to me, well, you've done all this hard work. Don't you want to stand for the election? And I mentioned to him that I was prohibited from standing for election by virtue of my membership of the BLA. So it'll give the commission some idea of how far the attorney's profession has come, that once you had put your colors to the BLA mast, you were on the outside of those people. You weren't part of them, and you couldn't even stand for election amongst them. And so what happened was, I was asked by Mr. Mabunda, would I be interested in standing for election, because he felt that I would be able to help bring our shared values to the council if successful. And I agreed to do so. And I mentioned the last time, and I think it's an important thing for me to say, that I specifically recorded in my letter of resignation from the BLA that I was not resigning for any reason other than the fact that I was being asked to undertake this task in the wider interest of not only the organization, but the profession. So that's what I did. And as things worked out, I then found myself at the Law Society of the Northern Provinces as its president. So I then became the president of the Law Society with a new council reconstituted on the white side. The BLA and Nadel colleagues were still there. But now we had a very different situation because we had a majority on the council who now shared a vision of actually getting things moving forward. And we started to then do things within the scope of our powers that were governed by statute to make things happen and make things move forward. And I think we made a lot of progress in the relatively short period of time that we had. One lament which I have, and Mr. Sigogo knows that I've previously mentioned this not only to himself but to other members, is that we didn't reach that situation 15 years earlier, because who knows where we would have been by 2015. But that, as I said, is a question of the passage of time and one's maturity and one's experience with these things. So once I was the president of the Law Society of the Northern Provinces, as part of what we were doing, we reactivated the Transformation Committee, which had been a dormant committee because no one had really been interested in getting things moving. So we reactivated the committee and tried to take steps to get projects moving forward. I gave a lot of attention to the pro bono department. It was a very small department, which I tried to have elevated into being a fully fledged department, because it was doing essential work primarily to those from disadvantaged circumstances. So we tried to expand that. We weren't successful in getting agreement to actually make it a fully fledged department, but it was still a very important unit of the LSNP, the Law Society of the Northern Provinces. So we managed to achieve that. I also took up a seat on the Law Society of South Africa in my capacity as the president, and was now exposed to the wider attorney's profession, not just for Northern Provinces, which was where I'd been elected, but now nationally. So now I had exposure and interaction with colleagues across the spectrum, and found many who shared the same views that I did, and who were moving towards and wanting to move towards the same shared common vision of a transformed profession where...
Sorry, Mr. Millar, I know it's a lot that you can say on this topic, yes, because you indeed played a role, but I think I should cut you here so that for the benefit of time, yes, and I believe other councillors will engage you on similar topic. Yes. Thank you, CJ.
Thank you, Mr. Sigogo.
Thank you, Commissioner Sigogo. Honorable Dodovu.
Thank you, CJ. Good afternoon, Mr. Millar.
Good afternoon, Mr. Duval.
18 months ago, you were here applying for the similar position. Not that you were a bad candidate, but I think we were spoiled for choice. We had very, very good candidates appearing before us, and we had to make a decision. And this time around, you are here. What is it that is exceptionally good about you when we compare to 2019? Or just give us something that will make you outstanding, better candidate for selection. Yes.
Mr.
In short, yes.
Yes, Mr. Dodovu, I bring a lifetime commitment to improving not only the lot of the general public of South Africa, the people who need it, but also to the legal profession. I bring my energy, my commitment, and my passion to see that happen. That is what I bring. I work hard. I think the JP's got the statistics. I deliver judgments timelessly. I'm very conscious of the fact that litigants need to know what the outcome of their cases is. It's an integral part of the access to justice, is to know the outcome of your case. It cannot be that you must wait extended periods of time. You've already waited an extended period of time to get to court. Now you must wait in a further period of time. So I bring a passion for service delivery, for wanting to ensure that the rights of the people of South Africa are properly looked after and properly represented.
Thank you very much. My second question, I read your judgment of 2018 on Ngobo versus the Minister of Police about unlawful arrest and unlawful detention. Does it follow, in your view, does it follow that when the arrest is unlawful, therefore the detention will be unlawful?
I see it slightly differently, because each level of government has its own responsibilities. We're all bound by the principles of Batopele. So when the policeman exercises a power to arrest, if it's unlawful, then once it comes before the court, the prosecutor must look at the matter and see, is this person properly arrested? It cannot be that one person takes an action and everyone else is absolved and doesn't bear any responsibility. At each level, responsibilities must be exercised. And so that is my view. I don't recall the specific case you're referring to. Perhaps you can refresh my memory. Is it the case where there was a warrant for arrest, but then the prosecutor, yes.
And you found a prosecutor, I think, involved liable for,
yes,
for damages.
Yes, in that particular case, the warrant of arrest, there in fact had been a warrant of arrest issued by a magistrate. So the question of the legality of the arrest wasn't an issue. It was a question of what happened after the man was deposited at the police station, or once the man came before the court, and the prosecutor now had the evidence in front of him, and it didn't bear scrutiny. And by the time the criminal case had come to an end, the prosecutor in that case actually conceded to the court that there had never been any basis to detain or prosecute Mr. Ngobo. And on that basis, the prosecution must bear responsibility, because the continued detention was no longer at the instance of the police.
No, thank you. I heard you.
Yes.
Thank you, CJ.
Thank you.
Thank you, Honorable Dodovu. Prof.
Thank you, Chief Justice. Good afternoon,
Good
sir.
afternoon, Professor.
Mr. Millar, I have one serious question that I want to put to you, and that relates to the criticism that the GCB has made to the lack of judicial reasoning in your judgments, and also linked up now to your answer to the Commissioner Dodozu when he asked you what you would bring to the bench. And your main focus was your contribution to the legal profession and the society. I didn't hear anything about your contribution to the development of the law or the fact that since we have, and I didn't expect you to say that out loud, the fact that we have an unwritten, uncodified system, that it is very important for judges when they write their judgments that people are able to glean the legal principles and that everyone can understand where our law is going to as well. Would you mind talking to us about that, please?
Professor, the two matters that the GCB specifically spoke to and raised criticism were both urgent applications. So I think Ms. Kane accepted the explanation that there was a time factor in those matters. The vast majority of cases that I've had the privilege of hearing haven't been cases that are legally of a nature where the law is going to be developed. The vast majority of cases seem to be cases where the principles are settled, and it's an application of the settled principles. People must know what the outcome, what was considered and what the outcome of the case is. The judgments are written for the litigants. That's really my focus, because that was my experience, is that the litigants want to know. I have a difficulty if one has to craft a judgment that now requires the litigant to go and pay someone to explain to them what's just happened to something that, pardon me, which could affect their life. So yes, I think it goes without saying, one would want to contribute where appropriate cases came before one that required deep consideration and development of the law and the legal principles. One would bring that mind to bear and would bring dedication to ensure that that was done. But that hasn't been the type of case that I've had. And one doesn't get to choose what cases one has. One really deals with what is there and must discharge one's duty with what is there. I don't think the criticism is a fair one. And I say the criticism is not a fair one because, and I did look at it seriously when I saw the comment of the GCB. Of the 120 judgments that I've delivered, 48 of them have been reported by JUTA in their online law report offering. That's 40%. And I think I can accept that if we speak about individual judgments, I'll be able to address what happened or what the time constraints were or what informed the approach. But as a general proposition, I think if JUTA, without any input from me, has picked up 40% of them and published them in their online offering, I think, then that's a factor which I think ought to be considered as well.
Just to follow up, CJ, are you referring to the SAFLI and
No,
not SAFLI?
Not SAFLI. SAFLI is a platform which is partially sponsored by the Legal Practice Council, which collates every single judgment handed down in every single court. It's a simple database where everything is put. The JUTA publication is a private publication. JUTA are the you know who JUTA are. They publish the blue books and the bound books that clients often see in lawyers' offices. So they're a private publisher. They aren't a
No, I understand that. The reason why I'm asking this question is just because some of the candidates that came before you said only judgment that are requested are put on SAFLI and then don't automatically end up there. So, but you don't have to answer to that.
I can perhaps amplify. The judge president will know that there's a directive that when you hand down a written judgment, your secretary is required, you're required to send not only the word format of the document to your secretary, but also the signed PDF document, the scanned document. And your secretary then sends both of those to the library. So that is the practice in both Pretoria and Johannesburg where I've acted. And every time I've authored and penned a judgment or handed down a judgment, that has been the procedure I've followed. So that ought to happen. I did understand that there were some snags in the libraries with the uploading of the documents. So at times it looks as though there's very few judgments from a particular division, and then you look 3 weeks later and you can't believe how many others have been added because they've now caught up with the uploading. But SAFLI is simply a database of all judgments that have been delivered.
Thank you, Chief Justice.
Thank you, Professor.
Thank you, Prof. Honorable MEC.
No, thanks, Chief Justice. I'm covered. Thank you so much.
Thank you very much. Advocate Mpofu SC.
Thank you, CJ. I'm covered too. Thank you.
Thank you. Honorable JP Leo.
Thank you, Chief Justice. Good afternoon, Mr. Millar.
Good afternoon.
Yes, I don't know whether you have seen the a letter written by Mr. Ronald Bobrov, dated the 8th of March 2021.
Yes.
Relating to, it's a bulky document. Do you have a comment with regard to that document?
Yes, JP. Earlier on, I spoke about my work on behalf of clients to recover fees that had been overreached from them. A great deal of that work was in cases where those clients brought actions against Mr. Ronald Bobrov. There are numerous judgments which can be found on SAFLI and reported judgments dealing with those specific cases and the circumstances relating to what happened there. In every instance, I acted on behalf of clients in matters which came before the court and which were decided by the court. For some reason, Mr. Bobrov, who has since been struck off and has fled to Australia to avoid arrest, has embarked on a campaign of vilification. He writes letters which, with all due respect, JP, I have read that letter. It is bizarre in the allegations that it makes. It's more suited for Ripley's Believe It or Not, a TV program, than it is for reality, because it doesn't withstand the scrutiny of the judgments of our court, which deal with the misdeeds of Mr. Bobrov and his son. The letter is written it's written out of spite. It's written with malice. It bears no relation to reality. And it would be my submission that this commission would dismiss that letter as being of no consequence. I might mention that there are a number of persons in the room who've been party to cases dealing with Mr. Bobrov, from the Constitutional Court to the Gauteng Court, and even counsel present who've also consulted with me and acted in matters pertaining to the conduct. So I don't want to go any further. Perhaps I can leave you with this, that the Supreme Court of Appeal is presently there's a judgment awaited from the Supreme Court of Appeal, which deals with many of the things that have been said. It pertains to an order obtained by the Asset Forfeiture Unit for the forfeiture of 100 million rand that was moved to a foreign country by Mr. Bobrov.
Yes, can I make a follow-up? Are you saying then, despite the fact that these allegations came from Mr. Bobrov, who is a fugitive from justice, that as a result of that, the Legal Practice Council did not deem it necessary to look into some of the issues that are raised in that complaint?
JP, all these issues that are raised were raised previously over many years. These aren't recent allegations. Everything in that letter predates the Legal Practice Council's existence. It all relates to things that happened from about 2011 or 2012 onwards. And during that period, Mr. Bobrov and his son were in the Republic. They were operating a law firm. They lodged complaints. They were dealt with by the proper structures and dealt with properly by the Law Society. Not once did they ever institute action in respect of any of those things. It has absolutely no basis in fact or in law, and I really can't take it any further than expressing that to you.
Thank you.
Yeah, I can't make out my handwriting.
It could be me, Chief Justice. I'm covered.
Yeah, and it's you. Now I see it's you. Yes. Commissioner, thank you, sir. Commissioner, is there a follow-up?
No, CJ, it's
me. It's your turn. Yes. It's your turn. And I thought I heard the voice.
Chief Justice, I have follow-up. It's Barnard.
Oh, yes, and I had skipped you by mistake. Over to you, Commissioner Barnard.
Chief Justice, the question I want to ask, I will still ask when you give me an opportunity, but I'll follow up on what has just been discussed, if I may.
I think do everything then.
All right, so let's start with that question then, Mr. Miller. Just before we get back to that, you also do some valuable work involved in the small claims court. Perhaps you could tell the Commission about that. The Randburg Small Claims Court, I believe, is quite an active court.
Yes, thank you, Commissioner Barnard. I've served in the Randburg Small Claims Court for 18 years, and 10 of the years until this year passed, I served as the convener of the. Every small claims court has a minister or an advisory board, which sends input to the minister relating to the operations of the court, so as to facilitate the smooth running of that court. It's a very busy court, and I'm proud to say that I think I've made a good contribution with the other commissioners who sit there and who serve with me on that advisory board. We've been able to really ensure access to justice for those who can least afford it. We've made accommodations, and we've organized the court in a way to accommodate those who don't have access to private transport and various other things. Commissioner Barnard, you'll know that a number of years ago, we did discuss this issue of the small claims court in the context of the app that you were developing for free distribution to the public to empower access to the small claims court. So I think it's really the first port of call for those who have the least means, and it's their first experience of justice without having to put their hands in their pockets or to go and ask for assistance somewhere else. It's absolutely crucial and essential, and I'm proud to have served there for 18 years and to have helped to bring conclusion to the matters that came before me there.
Thank you. That also just reminds me to disclose that we did serve together on the LSSA for a period while you were there as well. Maybe just for the benefit of the Commission's knowledge. I'd like to, and as far as the Chief Justice will indulge me, just raise a couple of the specific issues in the interests of transparency that are raised by the Bobroff letter. And if you can please give brief answers on those, or if you feel you need to expand. First one is, there seems to be an allegation that your practice address is no longer accessible to someone who tries to contact it. That files have been handed over to, I think I saw the name Volmerant somewhere in the document, or Volmerant's attorneys. And so that's the first question. If you can maybe just, apparently they've phoned and there's been no answer at practice, etc.
Yes, well, after COVID, my partner, who's reached the age of 83, decided he wanted to retire, and the decision was taken to downscale and reorder the practice. I did see in the letter that Mr. Bobroff had obviously sent someone to our prior business address and was most concerned about the to-let sign. Those were business premises. We've moved. The Legal Practice Council has been notified of the new address as is required by the regulations, and I really can't explain why the Legal Practice Council wouldn't have given the new address to Mr. Bobroff. He would have to amplify upon that. But compliance with the Act and regulations, I serve on the council. You can take poison on the fact that we are fully compliant.
Thank you. I'll move on. The next one is an allegation of touting, and there are any number of, or a whole number of touting allegations. And the thread seems to be that there was a person by the name of Jabu who worked for your firm and then touted or solicited work to the practice. Yes,
that's absolutely false and untrue. Mr. Bobroff at the time corralled a group of clients who ostensibly made those complaints. We came to the Law Society for a hearing. The clients were there. Mr. Barnard, I'll just mention, because it's important in the context of this question for the commissioners who've read it, Mr. Bobroff sent an advocate and an attorney to come and listen to the hearing. And when they were asked by the panel, what is your capacity? Why are you here? They said they were there as observers. And the panel said, but this isn't a public proceeding. The complainants can be heard and the attorneys can be heard, but you cannot be here as observers. Are you representing the complainants? They said no. And on that basis, the panel excused them, said it wasn't a public proceeding. And the rules of the then Law Society didn't provide for a public hearing. Once the hearings got underway, the evidence was from the ladies and gentlemen who testified. They said, where is my money? I still remember the vernacular term that was used because each one said it. Ufuna imali nyami. And the panel then said, "What? But why?" And when they were questioned, it then came out that every letter of complaint had been written by Mr. Bobroff's clerk, and that they'd simply affixed their signatures and been told, just sign this document and come here and you will get money. So when they sat down, they said, well, we're here, we want our money. Then the panel questioned them, and I was there, and I also had the opportunity to question them, and we dealt with the individual allegations that were made. And they said, but that's not true. And we never said that, and we never wrote that statement. And they pointed to the man concerned and said, he wrote the statement. And at the conclusion of the hearing, he was then brought into the hearing, and he was questioned, and he conceded that on the instructions of Mr. Bobroff, he had done it. The context of that complaint and that situation was a full bench hearing in a case which declared the use of so-called percentage common law contingency fee agreements invalid and illegal. In other words, what was happening was a concerted effort to stop me from bringing the case to court, which would put an end to the gravy train that Mr. Bobroff and many others like him were riding. And that is what happened. The issues were fully ventilated. There is a transcript at the Law Society. It bears out everything I've said. And interestingly enough, this was in 2013 or somewhere around there. Nothing ever further was done about it or ever came of it. It's raised only in terrorem to try and improperly influence this commission.
The use of unlawful contingency fee agreements, various clients are mentioned, various agreements, but the question is, you being aware of contingency fee agreements and the statutory requirements, have you ever used an unlawful contingency fee agreement with clients?
No, not ever. I would never do it. It's immoral, it's reprehensible. My views on it are very well known, and I stand by those views. Till the day I die, I'll stand by those views.
Thank you. And then on the circumstances of the election that you referred to, did you disclose to the colleagues at the time of the election that you had resigned the previous evening from the BLA?
I was asked at the meeting, which took place in order to hold the election. I put forward the resolutions. It was a special meeting of the Law Society, and I was asked specifically in the meeting, are you a member of the BLA? And having resigned shortly before midnight the night before, I said correctly, I am not a member of the BLA as I stand here. The minutes of that meeting are also available. And that was correct. I was not a member of the BLA on that day.
But I think the question is, did you disclose to them that you had been until the previous day?
It was common knowledge that I was a member. It was common knowledge. It wasn't an issue. The right to call for the election and so on was open to all members. The statute and the way the profession had been structured wasn't the difficulty. It was the voting that was the difficulty, because the special resolution called for a vote of the so-called statutory or white component. It didn't relate, so anyone could have called for the election. It didn't matter whether you were a BLA member, a NADEL member, or a member of no organization. But once it became an issue as to the voting, yes, there it was an issue, and those are the circumstances under which it happened. I can assure you, Mr. Barnard, if there was anything impeachable that happened, I have no doubt that those that tried to prevent the holding of the election would have taken steps to raise it and would have done it. Everything was done absolutely above board and according to law.
Thank you. And I'm almost done, Chief Justice. If I may just have one or two more questions with your permission.
Go ahead, Commissioner Barnard.
Thank you, Chief Justice. Mr. Miller, have you ever tried to block any complaint that was laid at the former office or the former Law Society of the Northern Provinces? Have you ever tried to quash any claim that had been lodged there by anybody for that matter?
As the president of the Law Society and a member of the council, I had nothing to do whatsoever with the administration, other than to see that the staff were empowered to do their work and to then take decisions according to law. I've never been involved in such a thing, and I would never do such a thing. I think the way in which I've addressed this and my reputation is that if there's something to be dealt with, I meet it head on. I have no need to quash things or hide things. I will deal with whatever is put before me head on, and that is the basis for it. So absolutely not.
And my last question then is as far as information obtained from the offices of Mr. Bobroff, there's an allegation seems to be that there was almost a clandestine flow of information from one of Mr. Bobroff's staff members out to someone that's mentioned, and then it was passed on to you, and then your firm used it for gain of your firm. Is there anything,
absolutely untrue? Every client who instructed me found me and came to me on their own, and nothing arose from the office of Mr. Bobroff. In regard to the flow of information from Mr. Bobroff's office, there was a whistleblower who is protected under the legislation. The information provided by that whistleblower was not used by me and had no value to me and was nothing to do with me. It was provided to the appropriate authority, and the appropriate authority dealt and is dealing with it. But I certainly gained nothing. Mr. Barnard, Mr. Bobroff cannot accept responsibility for what he's done. And so the allegations, as one reads his letter, become more bizarre and more outlandish. It's everyone else's fault. It's part of a grand conspiracy. As I indicated earlier, it's really something from Ripley's Believe It or Not. It ought not to have been before this commission, with respect.
Thank you, Mr. Miller. Chief Justice, thank you for the indulgence.
Thank you, Commissioner Barnard. Commissioner Tsepe?
Chief Justice, thank you. I'm covered. Thank you.
Thank you very much. Thank you, Mr. Millar.
Yes. Just, I'm so sorry. May I have one follow-up to Mr. Barnard?
Yes, Honorable Breitenbach.
Thank you, sir. Good afternoon, Mr. Miller.
Good afternoon, Ms. Breitenbach.
I'm afraid that I'm an old prosecutor and old habits die hard. Would you agree with me that if Mr. Bobroff wanted to be taken seriously, he should come here and say that?
Well, Ms. Breitenbach, I think you're 100% correct. A lot of allegations are made while he sits over the sea in Australia. And if there was any basis for any of the allegations he's made, he would come here. He asserts that he's innocent and that he was improperly struck from the role, but he's never prosecuted his appeal against his striking off. I think. No,
I mean the allegations against you. If he wants to be taken seriously, he should come here and say it.
Yes, the allegations against me, he must. If there was any basis, he should come here and do it. It seems improper that fugitives from South African law can pull the strings from afar.
I agree with you. Thank you.
They must stand by their words and face the consequences if it's found to be false. And
thank you. You've answered my question. Thank you.
Thank you, Ms. Breitenbach.
Thank you very much, Mr. Miller. You're excused.
Thank you, Chief Justice. Thank you, members of the Commission, for your time.
You are excused.
Thank you.